Hi, I'm Debbie Moraes. This is Legal Matters, the program that's designed to address some critical and controversial issues that are facing some consumers and businesses today. It's legal information, it's practical solutions, and straight talk about a wide variety of topics. Very recently, we've been discussing things that matter most to consumers and businesses as it's pertained to flood. Things as practical as traffic violations and you and your municipal court, considering we have two judges with us. With us again today, Jackie Grasso and David Bizarre from Odette Bizarre Cordero Grasso Law Firm in East Providence. We thought today we would continue with some very controversial and interesting topics, the one about ethics. We will have you set it up, but essentially there's a question about attorney-client privilege. That's supposed to be sacrosanct. Theoretically, whether I'm talking to my minister or my rabbi or my lawyer, no one is supposed to be able to violate or breach that confidence. Well, an interesting topic is in the news today, so we're going to flesh that out. Okay, David, do you want to set that up?
Sure.
A little bit?
Recently, there was an issue where an attorney was faced with the problem of having a client's confidence which held a secret as to somebody who was actually convicted of a crime who apparently shouldn't have been, and whether or not he had the either obligation, right, or ability to turn that information over to the Attorney General so that justice, so to speak, could be done. And that does hit on the issue of what is protected in an attorney-client confidential statement or issue between client and attorney.
So what is that privilege? What is that client-attorney relationship that's privileged?
Anything a client tells you, discloses to you, even as much as documents, anything that they give you is considered confidential. You are not able to disclose any information to anyone else without written consent from your client.
Great. And let's go back just a step.
With few exceptions.
That's right. And we're going to talk about the exceptions. But if you go back a step, attorneys practice under a code of professional responsibility, ethics rules. It's so important to the practice of law that there's actually someone who works for the Supreme Court, who's the head disciplinary counsel, who makes sure that attorneys follow those rules. And if you violate a rule, unlike almost any other profession, you can have your license taken away for an ethical violation as opposed to malpractice or incompetent practice in other areas. So this is a very important and serious issue for attorneys, knowing the rules and following the rules. So what happened for this particular attorney with the information that he had is he sought the advice from that disciplinary counsel to say, what do I do under this situation? What is my responsibility? So these are things that we deal with, not only in attorney-client privilege, but in many other areas of the practice of law.
And my understanding, too, with that issue is that disciplinary counsel asked for an opinion from the Supreme Court.
Right.
That gave him basically the green light to go ahead and disclose that information.
And what you need to know is the disciplinary counsel works for the Supreme Court. The Supreme Court is responsible for interpreting how the rules of ethics are applied.
So you would think that he was initially saying I could be disbarred for having breached that privileged communication. Yet, as you're saying this, he's gone already to a higher power and essentially got a pass. Not a pass. Here's the greater good. You have to let this be known because someone else is wrongfully being incarcerated. This woman was in jail for 3 years, I suppose.
It was 3 years. It was 3 years.
And now all that's happening, even though there is now, because of this lawyer's disclosure, all there is another trial. In fact, the lawyer now knows and helped to, never mind implicate, make very clear that it was the boyfriend, not the mother who committed the crime. Yet it's just going back to an open trial. What's the issue with that? Why would that happen?
Well, here's the situation. First of all, it reminds me of a movie actually I saw for the first time very recently, Witness for the Prosecution. This is what he's been told. It's really not clear, I don't think, 100% that it's what happened. What if the client was lying to him?
Which time, David?
Well, that's exactly correct. Yeah. So the Attorney General is still free to weigh all the evidence, look at the evidence, circumstantial evidence, physical evidence, all the evidence that goes into a case, and determine whether or not there's still enough evidence to go forward with a trial. this happens all the time. You have these cases where people are on death row or locked up for life with DNA evidence coming out, and a lot of times that gives them the right to a new trial. But the Attorney General, whoever is responsible for prosecuting a case, still has to make a determination whether there's enough other evidence to go forward with a case.
Curiously, I mean, ethically you would say that you're supposed to serve justice, and justice was not being served. That's the greater good. So what takes the precedence over the breach of confidence with the client or the greater good being served? Clearly,
there are two categories here. There's your
tell.
ethical responsibility and your moral responsibility. I tend to think it was probably more of a moral responsibility, at least that's my opinion, more than it was an ethical responsibility, because we're trained as lawyers that confidence is sacrosanct, as you
Yes.
said, unless one of several things happen. The first being you have written consent from your client. The second being if there's any imminent bodily harm or
Yeah.
danger to another person, if you know they're committing perjury. And I
That-
don't see that category here.
Well, but what I don't know, see, is whether or not this fellow testified in her first case.
We're also missing some
So
information.
if he had testified in the first
And he
case
knew he committed
and the
perjury.
lawyer knew that, then that may give the Supreme Court that reason to open up the case and say you can violate that confidence of your client, because we're officers of the court. So there are two things that are very important here. Number one, you want a client to be able to tell an attorney anything and everything.
including that you committed the crime?
Yes.
Well, if you're a defense attorney, you may not want to know that, but you don't want to prohibit the client from being able to tell you everything he thinks and you think you need to know from him in order to defend or protect that client's rights. However, and the reason a lot of defense attorneys may not want to know that somebody's committed a crime or is guilty of what they're charged with is because we're also officers of the court. And as an officer of the court, we have a duty not to let fraudulent evidence be presented to a tribunal or in front of a judge. So if in this case, the attorney who had the confidence knows that his client lied, he does have the obligation then to break that confidence and come forward.
Curiously, while this was making headline news in the past week, there was also various lawyers who weighed in on above all else, do not violate that, even in view of it not being imminent death or imminent injury. She was in jail, but she wasn't ready, as you say, to have the lethal injection. But they said even if she were, that the greater good is being served. And many weighed in and said they would absolutely take to their deathbed or whatever, that they would absolutely stand by the client and never divulge and certainly never become a witness in the next trial.
We're missing on some of the
The facts.
facts here because we don't entirely know all of the
Right.
intimate facts of the case. So it could very well be, as David said, that his client, the attorney's client, actually did commit perjury on the stand, and then you get your green light, so to speak.
Right. If he didn't, and we don't have one of the 2, 3, 4, whatever exceptions that you have, it's a much tougher case. And those other attorneys who said they would take it to their deathbed may be morally, ethically in conflict with each other, but legally have to probably hold that confidence, because it's the client's confidence you're holding. It's not your right to disclose the client's confidence. It's the client's right to allow you to.
Tell me, are there other exceptions? For example, I was reading one that said if that man who did supposedly now commit that crime, if he had divulged that information to any other person, that then opens...
Yes,
Mm-hmm.
that waives
attorney,
the privilege,
that waives
because
the
now if it's another person who I'm assuming is not an attorney,
Yes, that's what...
now the privilege is gone.
Yeah, there's a very narrow exception to
Yeah,
that.
yeah.
If someone comes in to talk to you about a case and you have a paralegal that's working on the case, an employee of the firm, that doesn't waive the privilege. But if someone comes to Jackie for a divorce and they bring their girlfriend